right. Still right. It's 10 o'clock in the morning. I'm in time.
The Honorable President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Paula Gopi-Schoon, Senator Anthony Vera, and Senator Dr. Varma Dayal Singh, all of whom are out of the country, and Senator Tahaka Obika and Senator Ashwani Mahabir, both of whom are ill. Honorable Senators, I have received the following correspondence from Her Excellency the President, Paula May Weeks, ORTT. To Mr. Wayne A.M. Innes, whereas Senator the Honorable Paula Gopi-Schoon is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the acting Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Wayne A.M. Innes, to be temporarily a member of the Senate with effect from the 4th of June 2019 and continuing during the absence from Trinidad and Tobago of the said Senator the Honorable Paula Gopi-Schoon. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 3rd day of June 2019. To Ms. Folade Mututa, whereas Senator D. Vera is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Folade Mututa, to be temporarily a member of the Senate with effect from the 4th of June 2019 and continuing during the absence out of Trinidad and Tobago of Senator Anthony D. Vera. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 3rd day of June 2019. To Mr. Elton Prescott, SC, whereas Senator Dr. Varma Dayal Singh is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Elton Prescott, SC, to be temporarily a member of the Senate with effect from the 4th of June 2019 and continuing during the absence from Trinidad and Tobago of the said Senator Dr. Varma Dayal Singh. given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 3rd day of June 2019. Honorable Senators, Senators are required to take the oath.
I, Wayne Innes, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Fulade Mututu, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Elton Prescott, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Honorable Senators, I am awaiting 2 further instruments of appointment from the Office of the President, and when I receive them, with your leave, I will revert to this item on the order paper.
Bills brought from the House of Representatives, petitions, papers.
Acting Leader of Government Business.
Thank you, Madam President. I have the honor to lay the following papers as listed on the supplemental order paper in the name of the Minister of Finance, the Minister of Public Administration, and the Minister of Health. The report of the Central Bank of Trinidad and Tobago with respect to the progress of the proposals to restructure CLICO, BAT, and CIB for the quarter ended March 31st, 2019. The annual report of the Telecommunications Authority of Trinidad and Tobago for the year 2018, and the Tobacco Control Amendment Regulations 2019. Thank you.
Reports from committees.
Senator Mark.
Thank you, Madam President. Madam President, I have the honor to present the following reports as listed on the supplemental order paper in my name. The 17th report of the Public Accounts Enterprises Committee on the examination of the audited accounts, balance sheet, and other financial statements of the Export Centers Company Limited, ECCL, for the financial years 2008 to 2011. The 19th report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the Cocoa Development Company of Trinidad and Tobago Limited, CDC-TTL, financial years ended September 30th, 2014 to 2016. And finally, the 21st report of the Public Accounts Enterprises Committee on the examination of the audited financial statements of the Trinidad and Tobago Free Zones Company Limited, TTFZ, for the financial years 2012 to 2017.
Agriculture, Land and Fisheries.
Madam President, I have the honor to present the following reports as listed on the supplemental order paper in my name. The second interim report of the Joint Select Committee appointed to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018, and the second interim report of the Joint Select Committee on the Mutual Administrative Assistance in Tax Matters Bill 2018, the Tax Information Exchange Agreements Bill 2018, and the Income Tax Amendment Bill 2019. Thank you.
Urgent questions?
Senator Mark.
Thank you, Madam President. To the Minister of Finance, in light of reports that a US $720 million syndicate loan has been secured by Trinidad Petroleum Holdings Limited, can the Minister outline the conditions associated with this loan agreement?
President, I understand that the Minister of Finance is on the way, and I'm respectfully asking that this question be stood down as we await his arrival.
Yeah. Next question, Senator Amin.
Thank you, Madam President. To the Minister of National Security, having regard to reports that a Jamaican national was allowed to leave the Piaco International Airport after being denied entry by the Immigration Authority, can the Minister indicate what steps are being taken to locate and deport this individual?
Acting Minister of National Security.
Thank you very much, Madam President. Madam President, the exact fact and circumstances as to the event is being investigated. The reality, however, is that that Jamaican national is now at large. As such, his photograph and descriptions have been made available to all units of the Trinidad and Tobago Police Service and to other elements of the security platform in this country, and efforts are being made to locate him. Once he is located and found, he will be handed over to the immigration authorities for their further management of the situation. Thank you very warmly, Madam President.
Senator Amin.
Thank you. I have a follow-up. Minister, has the Ministry of National Security or the Immigration Authority given consideration to changing protocols when dealing with situations like these within the airport?
Minister.
We already and always have a system of protocols in place, Madam President. But once a new situation develops and an investigation is completed and there is evidence that some breach or some weakness was identified, then naturally, Madam President, arrangements are made to tighten those gaps so as to prevent future occurrences in these circumstances.
Senator Amin.
Thank you, Madam President. Has the officers concerned been removed from their positions while the investigation is ongoing?
Acting Minister of National Security.
This question suggests loudly that this is putting the cart before the horse. When the investigation is completed, then one would be properly and reasonably in a position to know what was responsible for this unfortunate state of affairs, and it is only then that a sensible decision maker would contemplate all of the possibilities available to him or her.
Acting Prime Minister. Response to question 1.
Sorry.
Thank you, Madam President. Apologies for being late. The terms and conditions of the US $720 million proposed financing for Trinidad Petroleum will be made public upon finalization of the legal documents, which is anticipated within the next 7 to 10 days. The financing remains confidential, subject to disclosure rules associated with the company's exchange offer under U.S. Security and Exchange Commission regulations. However, Madam President, I can provide some information. The tenor of the loan facility will range from 3 to 7 years, and the amount in each tenor bucket will be finalized within the next 7 to 10 days. I can also say that the interest rate on the loan will be better than the rate on the US $850 million bonds that Petrotrin currently has issued.
Senator Mark.
Can I ask, through you, Madam President, if the Minister can share with this Honorable House the rate of interest on the $720 million US loan?
Acting Prime Minister.
Madam President, I can say that the interest rate will be better than the existing bonds. The range of reduction will be between 50 and 175 basis points.
Senator Mark.
Madam President, through you, can the Honorable Minister indicate when the legal documents have been finalized, whether this document will be tabled in the both Houses of Parliament for viewing?
Minister, Acting Prime Minister.
Madam President, I was very clear that the terms and conditions will be made public upon finalization of the legal documents, which is anticipated within the next 7 to 10 days. Therefore, if the terms are going to be public, there can be no restraint in laying them in this Parliament.
Next question, Senator Richards.
Thank you, Madam President. Good morning, everyone. To the Minister of Rural Development and Local Government, what immediate measures are being taken by the Port of Spain City Corporation to address the issues of poor sanitation at the Central Market?
Acting Leader of Government Business.
Madam President, I thank Senator Richards for the question. Madam President, 4 measures have been taken. The first is this problem emanates from the fish sale section of the Central Market. So on May 27th, 2019, that section was closed for refurbishment, and it would be reopened on June 11th. So the works would be conducted between May 27th and June the 10th. The second is this matter stems from an issue of productivity, availability of workers, and overtime costs. Discussions have been ongoing with the representative union. The third thing that has been done is that there are 28 short-term workers who have been hired to supplement the existing staff, and these workers would work at straight time and avoid some of the overtime costs. And the last measure is that there is in the development program for the Port of Spain City Corporation a project to refurbish that Central Market, and a request has been made to the Ministry of Finance for the release of $1.8 million for the purpose of conducting the refurbishment works. Thank you.
Senator Richards.
Thank you, Madam President. Through you, thank you, Minister, for the response. Can the Minister indicate if, in light of and in addition to the measures he has outlined, if there is a temporary maintenance schedule and procedure for sanitation at the Central Market?
There is, Madam President, there's always been a maintenance schedule, The issue relates to productivity, availability, and the cost of overtime. So to overcome that in the short term, 28 short-term workers have been engaged. There have been discussions ongoing with the union, and we also believe that the refurbishment works, the one carded from May 27, 2019 to June 10, 2019, together with the development works, which would cost $1.8 million, would improve the sanitation of the Central Market. Thank you.
Senator Richards.
Finally, through you, Madam President, has the ministry been able to ascertain if there have been any health risks posed in light of the breakdown of those situations you outlined?
Minister.
Madam President, the matter of health issues is a matter for the Ministry of Health and the Port of Spain City Corporation. Both have health inspectors who are available. And so far, I am not aware of any health situation that has emanated from the current situation with the sanitation.
Questions on notice, questions for oral answer.
Acting Leader of Government Business.
Madam President, there are 6 questions for oral response on the order paper. The government intends to respond to 5 of them. There is one question directed, Madam President, to the Honorable Attorney General, which is... Madam President, may I correct myself? The government is proud to say that we have 6 questions on notice today, and we'll be responding to all 6. And there is one question for written response, for which the response will be submitted by the end of this sit-in. Thank you.
Senator Mark.
Thank you very much, Madam President. Question number 143 to the Minister of National Security.
Acting Minister of National Security.
Thank you very much yet again, Madam President. The issue of the protection of Venezuelan and Cuban nationals from being exploited by unscrupulous employers and potential employers in Trinidad and Tobago falls under the remit of the Ministry of Labor and Small Enterprise Development. Only recently, the minister of that ministry was out there telling the national community what is expected of them in accordance with the laws that she and her ministry administers, and she must be congratulated for that. Notwithstanding this, Madam President, being aware of the difficulties faced by the undocumented Venezuelans here in Trinidad and Tobago, the Ministry of National Security, under the influence of soundly worked out policy led by the Prime Minister of this country, is in the process of registering this migrant population. In this process, undocumented Venezuelans and/or Venezuelans who have entered the country illegally or legally, and have become illegal by virtue of overstay and other reasons, are being registered with a view of facilitating official authorization for them to work lawfully in Trinidad and Tobago for a period of up to 1 year. This registration process, Madam President, commenced on May the 31st, 2019, and is scheduled to end on the 14th of June, 2019, with the exception of the holiday Eid al-Fitr. Further, the Trinidad and Tobago Police Service conducts routine and joint exercises with other agencies wherever crime attracts them or in an attempt to prevent crime. And Madam President, the newly established Special Operations Response Team, supported by they supported other units of the Trinidad and Tobago Police Service and other state agencies on raids that resulted in the detention of 10 men for such alleged exploitation. The reported victims are being protected and defended in this time and will be so protected throughout any trials that would flow from this. It is also noted that such victim-centered protection and service encourages the willingness of victims to testify, resulting in more convictions. Higher conviction rates will not only reduce the possibility and deter the possibility of exploitation by employers and potential employers, but will also inherently protect these foreigners from such exploitation in our space. Thank you very much, Madam President.
Senator Mark.
Madam President, can the Honorable Minister indicate to the Senate what were the expectations that would have been outlined by the Minister of Labor to employers and potential employers as it relates to the exploitation of Venezuelan workers as well as Cuban nationals?
Acting Minister of National Security.
Since you permitted the question, which is already, the answer is already in the public domain, Madam President, all I can say is that the Minister of Labor would have identified the current legal platform that exists in Trinidad and Tobago and elaborated upon them in great detail, sufficiently so that any ordinary common sense citizen would have understood them.
Senator Hosein.
Thank you very much, Madam President. In light of the Minister's announcement that the Venezuelans would be allowed to work for a period of 1 year, can the Minister then indicate to this Honorable House what happens after the year has expired to the Venezuelan nationals?
No, that question does not arise at this stage. Senator Mark.
Can I ask, Madam President, upon the finalization of registration of Venezuelans in this country, can the Minister indicate what other services would be made available to the Venezuelan population outside of labor protection measures as outlined earlier by the Honorable Minister?
Senator Mark, I'm not going to allow that question. While the Minister in his response gave some more information about the registration process, the question posed initially, I'm not going to allow that question. You have 2 more.
Can I ask the Honorable Minister, therefore, what steps are being taken by the government to root out criminal elements that seem to find places within our spaces in this republic from Venezuela? Can the Minister indicate what steps are being taken to deal with that situation, Madam President?
Senator Mark, I won't allow that question, and I will ask you, as you ask your last question on this, to look at what you have posed. It's about employers.
Can I ask the Honorable Minister what specific measures have been employed by the government to beef up the Labor Inspectorate Division in order to ensure that employers adhere, Madam President, to the labor laws of this nation?
Senator Mark, that question doesn't arise. Next question, Senator Mark.
I hope this one would be helpful.
Well, it's your question that you're posing.
I'm hopeful.
Yes.
I'm hopeful. You know, we always live in hope. Question number 145 to the Honorable Minister of Health.
Thank you very much, Madam President. The Ministry of Health has implemented its adverse events policy as an institutional framework for managing, investigating, and reporting adverse events for all patients in the private and public health sectors. This occurs when the nature, likelihood, and severity of risk for legal liability of an event is high. The policy defines the standardized processes on the prevention, identification, reporting, disclosure, investigating, analyzing, and managing of adverse events. The clinical disclosure of adverse event occurs within 24 hours of a practitioner's discovery, and the institutional disclosure takes place generally within 24 hours, but no more than 72 hours after a practitioner's discovery of an event. Further, there's a period of 30 days for investigation and submission of a full written report with analysis and corrective actions with follow-up consultations between the Ministry of Health and the management of health institutions, whether public or private. In some cases, the minister can request reported events to be analyzed by independent experts who understand the clinical circumstances and care processes involved and who are trained to recognize underlying systems flaws. Recommendations for preventative strategies are rapidly disseminated to all heads of units, clinical and non-clinical, especially when serious hazards are identified. It should be reiterated, Madam President, that all files and written materials generated as a result of an adverse event constitute personal medical information and are required to be maintained in a confidential manner for the privacy, security, and well-being of the patient or their next of kin. Madam President, there would be serious legal implications if this information were to be disclosed precipitously. No further information can be disclosed on this particular case at this time, therefore. Thank you very much.
Senator Mark.
Can the Honourable Minister indicate when would be the most appropriate time when information on this very important matter of public interest would be made available to the general public?
Minister of Health.
Madam President, I answer that in the body of my answer. Information of this nature is confidential and will be shared with the patient's family. The reading of medical reports into the Hansard, as wanted by the opposition, is something that should be scorned, that is something that should be discouraged. Madam President, when the PNM was in opposition, we never once sought to make political gain out of the Baby Cottle event or the Crystal Ramsumir event. The PNM never once sought to bring those two cases into the public domain. But my friends opposite see the distress of people and their families as political opportunity, and their macabre intentions should be denounced in the most vociferous manner.
Minister, please. A supplemental question was posed, and you've given the response, but the last part of your answer, I will ask you to apologize for the words.
I humbly withdraw it, but I simply want to state when the Crystal Ramsumir event happened and the Baby Cottle event happened, we never sought to make political capital out of it.
Senator Mark, your next, do you have another supplemental?
I think we should rid the Senate of this gentleman. Okay,
Mark, please.
Sorry, I asked no further question of the gentleman.
No, but you also have to withdraw what you just said.
I withdraw the withdrawal. No, I withdraw him getting rid of. I withdraw them. You happy with that, sir?
Senator Mark, are you moving on to the next
I'm going
question?
on. Yes, madam, let me pay attention to you because we have to deal with the ages shortly. All right, we'll have to address the ages shortly. Madam President, may I continue, please?
Yes.
Without any interruption. Question number 151 to the Minister of National Security.
Acting Minister of National Security.
Thank you very much, Madam President. Madam President, given the present situation in Venezuela, it is indeed possible that evacuation of Trinidad and Tobago nationals residing there may be required. As such, the matter of a contingency plan falls within the remit of the Ministry of Foreign and CARICOM Affairs, which ministry would assume the lead position if such a situation ensues. Should such an evacuation become a reality, the Ministry of National Security and its agencies also stand very ready and able to assist in the following ways. One, by providing travel documents to any citizen at short notice in distress to facilitate their return to Trinidad and Tobago. 2, identifying Trinidad and Tobago nationals. This identification will be done with the assistance of Trinidad and Tobago's embassy in Venezuela and the Ministry of Foreign and CARICOM Affairs. 3, by providing transportation by sea for the evacuees in such an unfortunate circumstance, by utilizing the fleet of vessels owned by the Trinidad and Tobago Defense Force, in particular the Coast Guard. It should be noted, Madam President, that diplomatic clearance for vessels to enter Venezuela's maritime borders would be necessary. The vessels can proceed to either Trinidad and Tobago Coast Guard headquarters at Stobles Bay in Chagaramas, the Queen's Wharf in Port of Spain, or Port Brighton in the Labidco project. The time taken to transit the Gulf of Paria from Venezuela to Trinidad and Tobago would be dependent on the point of origin or embarkation, and in the main could take as much as 60 minutes. And finally, the Ministry of National Security would assist by providing security and first aid care as may be necessary for the evacuees during the transit to Trinidad and Tobago, all very much available, ready for service if this situation ever becomes necessary. Thank you, Madam President.
Yeah, Madam President, in order to identify our Trinidad and Tobago nationals through the embassy in Caracas, we need to know the number of citizens in that country. Can the minister share with this Parliament how many citizens are located in Venezuela at this time?
Acting Minister of National Security.
That question did not form part of the one I came prepared to ask. I left my crystal ball elsewhere. The senator can make a formal and sensible request going forward, and we'd be happy to respond to it.
Senator Mark.
One can understand your behavior, no problem. Madam President, may I ask the acting Minister of National Security temporarily, can I ask him, Madam President, whether the embassy, the Trinidad and Tobago embassy, is functioning as we speak in Venezuela? Can I ask him that through you?
Acting Minister of National Security.
The answer, as far as I'm aware, is absolutely yes.
Senator Mark.
Can I ask the Honorable Minister whether there is an ambassador located at our embassy in Caracas at this time?
Acting Minister of National Security.
As I indicated, the embassy is in existence and functional. Where the ambassador is at this time, I'm unable to say. My crystal ball is elsewhere.
Senator Mark. Yeah. Next question, Senator Mark.
Yes. Question number 152 to the Minister of Social Development and Family Services.
Minister of Social Development and Family Services. Oh, I apologize. Minister in the Office of the Prime Minister.
Thank you, Madam President. In the month of July 2018, the Children's Authority of Trinidad and Tobago received allegations concerning the abuse of children at the Charrise Nursery. The nursery is a non-governmental organization managed by the St. Vincent de Paul Society of the Catholic Archdiocese. The Charrise Nursery receives a monthly payment for the care and protection of each child resident at the nursery. The government also supports the payment of the water and electricity bills for this and all other community residences, as informed by the Children's Authority of Trinidad and Tobago. The Licensing and Monitoring Department of the Children's Authority of Trinidad and Tobago commenced its investigations on August 8, 2018. Since that time, there were several subsequent investigative processes, with the most recent visit completed on 31st December 2018. The Children's Authority has advised that the investigations revealed that there were several allegations that were not substantiated, such as the claim that residents were not receiving adequate meals at the stipulated times, records were not maintained for donations received, residents were engaging in sexual activities, and visitors were allowed to stay overnight. However, the investigation did reveal that there were instances where corporal punishment was being used by some caregivers on the younger residents, and there was a case of verbal abuse by a caregiver. The investigation noted that the use of corporal punishment and verbal abuse by the caregiver are not acceptable at the Cyril Ross Nursery and do not form part of their standard care for the children. The Cyril Ross Nursery has used a disciplinary mechanism to address the errant staff. The investigation also identified 2 residents engaged in the use of cigarettes. The Cyril Ross Nursery is working with these children to address what appears to be a nicotine addiction. The investigation also revealed that the Cyril Ross Nursery is not in possession of the undermentioned standard documents: 1, an established code of conduct, a complaints log, and a disciplinary log. In addressing these matters, the Office of the Prime Minister and the Children's Authority of Trinidad and Tobago met with the Cyril Ross Nursery to discuss its findings and recommendations in an effort to provide adequate support for the Cyril Ross Nursery. As a result, several measures were implemented or are being considered for implementation. Measures taken to date are: 1, a sensitization session with staff of the Cyril Ross Nursery. The sensitization session conducted for the staff of the nursery was held on January 15, 2019, and covered the following topics: appropriate disciplinary measures to use, the welfare and best interests of the child, record keeping and documentation, and staff submission of application documents. A multi-agency meeting was conducted with stakeholders, including the National AIDS Coordinating Committee and the St. Vincent de Paul Society on February 5, 2019, to discuss the findings and recommendations that were made as a result of the monitoring visits at the Cyril Ross Nursery. The aim of this meeting was to develop a wraparound action plan to support further development and advancement of the Cyril Ross Nursery. The following recommendations were adopted for urgent attention. 1, the St. Vincent de Paul Society will convene a special meeting to consider the establishment of a board of management to oversee the operations of the Cyril Ross Nursery. This was in keeping with the standards for managing the nursery. The board will have responsibility for policy, development, human resource, and financial management, among other things. Development of a multi-agency support services matrix complied by the Children's Authority of Trinidad and Tobago and the National AIDS Coordinating Committee, outlining the services available by organizations committed to supporting the Cyril Ross Nursery. Review of pediatric HIV data to establish a support mechanism for children at the Cyril Ross Nursery for the next 5 years. Collaboration with other ministries and agencies to ensure that the clinical and psychosocial needs of children are met. Capacity building of staff through training programs offered to the Cyril Ross Nursery by the Office of the Prime Minister. Conduct and evaluation of internal and external programs currently being implemented at the Cyril Ross Nursery. Assess the need for transition services for the current residents in need of such services, as well as those who were former residents. The last visit to the Cyril Ross Nursery revealed that there has been progress made at this residence. Some improvements include corporal punishment has ceased, draft policies and procedure for the operation of the Cyril Ross.
Minister, your time has...
Thank you, Madam President.
Yes. Senator Mark.
Thank you very much, Madam President, and I thank the Honourable Minister. Can I ask, through you, Madam President, what mechanisms have been established by the Prime Minister's office to monitor the implementation of the various recommendations that the investigation proposed?
Minister.
Thank you, Madam President. Madam President, since the allegations were made, I would have instructed through the PS that our M&E team would provide continuous monitoring of the nursery. As a matter of fact, the Office of the Prime Minister is working closely with the Children's Authority as well as the team at Cyril Ross to ensure that all the recommendations are in fact implemented.
Senator Mark.
Can I ask, through you, Madam President, what action, disciplinary action, if any, would have been taken against the offenders involved in corporal punishment activity, as well as engaging in verbal abuse of children at this particular home, Madam President.
Minister.
Madam President, as I would have indicated in my answer, the nursery would have taken necessary measures to discipline the errant staff identified.
Mark?
Would the Honourable Minister be kind enough to indicate to this Senate what were the necessary and relevant measures of a disciplinary nature taken by the home to deal with these situations that we have outlined?
Minister.
Madam President, in going forward, the Office of the Prime Minister would have assisted the home in establishing a code of conduct, etc., for staff at the nursery. In terms of what would have done to the particular individuals indicated in terms of verbal abuse, etc., the nursery would have used their existing guidelines. However, going forward, we have worked with the nursery as well as the Children's Authority to establish policies and procedures, manuals, as well as a code of conduct.
Senator Hosein.
President, in light of the protection of these young children, can the minister indicate whether or not the offenders are still employed at the Cyril at the home, please?
Minister.
Madam President, I will verify that.
Senator Mark.
Can I ask the Honourable Minister to share with us, Senate, the monthly payment, seeing that you said that we, the taxpayers of the people, meet the monthly payment of this home through subventions. Can you share with us, Senate, what is this monthly payment? What is some?
No, Senator Mark,
involved?
I won't allow that question.
You won't allow it?
Next question, Senator Mark.
Is it a supplemental?
No, next question.
Okay. Thank you. Well, yes, Madam President, I would like, in accordance with Standing Order 27, sub 17, to withdraw this matter because I think that has been publicized since I filed this question.
The question is withdrawn. Next question, Senator Mark, on behalf of
Yes,
Senator
on
Obika.
behalf, Madam President, of Senator Tahaka Obika, I pose question number 255 to the Minister of Finance and Acting Prime Minister.
Acting Prime Minister and Minister of Finance.
Thank you, Madam President. For the period September 2015 to December 2018, the total dividends paid by the National Gas Company to the government totaled $7,628,479,281.45, comprised of $6,114,302,043.45 in ordinary dividends and $1,514,177,238 in special dividends that arose from the TTNGL, also known as Phoenix Park, IPO. And that was the mechanism used to send the proceeds of the IPO to the Treasury. The breakdown is as follows. September 2015 to December 2015, $2,170,423,800 in ordinary dividends, and the IPO proceeds of $1,514,177,238. For the period January 2016 to December 2016, $2,086,064,200. For the period January 2017 to December 2017, $1,350,194,716. For the period January 2018 to December 2018,
$619,327.45.
Senator Mark.
Yeah, can I ask, through you, Madam President, could the Minister indicate what has been responsible for the fluctuation of the contribution by the NGC, particularly in the last period of January to December of 2018, dividends paid to the state, to the government of TNT. Can I ask the Honourable Minister what may have been responsible for this decline from 2 billion to almost 500 million? Can you share with us?
Acting Prime Minister.
Among other things, Madam President, the preponderance of unresolved claims by end users left for us by the UNC government.
Senator Mark.
I'm good.
Okay.
Public business, government.
I'm going to revert now. No. Honourable Senators, I'd like to revert to item 2 on the order paper because I am now in receipt of the instruments.
Madam President, before you do, can I seek your indulgence on the written questions?
Sure.
Madam President, I'd like to seek your guidance on question number 256, which, as you know, is due on the 29th of the 5th.
The Leader of Government Business did indicate, the acting leader, that that would be available during this sit-in.
During today's sit-in?
Yes.
Okay, thank you.
To Mr. Sean Sobers, whereas Senator Ashwani Mahabir is incapable of performing his duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Sean Sobers, to be temporarily a member of the Senate with effect from the 4th of June 2019 and continuing during the absence of Senator Ashwani Mahabir by reason of illness, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's this 4th day of June 2019. To Ms. Haseen Sheikh, whereas Senator Tahaka Obika is incapable of performing his duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Haseen Sheikh, to be temporarily a member of the Senate with effect from the 4th of June 2019 and continuing during the absence of Senator Tahaka Obika by reason of illness, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President St. Anne's this 4th day of June 2019. Honourable Senators are required to take the oath.
I, Sean Sobers, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Haseen Sheikh, having been appointed a Member of Parliament, do swear by Almighty Allah that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Motions relating to the business or sitting of the Senate and moved by a minister.
Acting Leader of Government Business.
Madam President, having regard to the second interim report of the Joint Select Committee appointed to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018, I beg to move that the committee be granted an extension to September 27, 2019 to complete its work and submit a final report. Thank you.
Honourable Senators, the question is that the Joint Select Committee appointed to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018 be granted an extension to September the 27th, 2019 to complete its work and submit a final report. Those in favour say aye.
Aye.
Those against say no. The ayes have it. Acting Leader of Government Business.
Madam President, having regard to the second interim report of the Joint Select Committee on the Mutual Administrative Assistance in Tax Matters Bill 2018, the Tax Information Exchange Agreements Bill 2018, and the Income Tax Amendment Bill 2019, I beg to move that the committee be granted an extension to September 27, 2019 to complete its work and submit a final report. Thank you.
Honourable Senators, the question is that the Joint Select Committee on the Mutual Administrative Assistance in Tax Matters Bill 2018, the Tax Information Exchange Agreements Bill 2018, and the Income Tax Amendment Bill 2019 be granted an extension to September the 27th, 2019 to complete its work and submit a final report. Those in favour say aye. Aye. Those against say no. The ayes have it.
Public Business, Government Business, Bill, second reading.
Attorney General.
Thank you, Madam President. I thank my colleagues for that warm welcome as well to this honourable chamber. An act to amend, Madam Speaker, Madam President, I beg to move that an act to amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Madam President, as I look around and recognize some familiar faces and some new faces, I welcome certainly all senators to this very important sitting this morning. We are here to discuss a rather narrow issue which has been brought upon us by way of a very dedicated push towards the operationalization of laws intended to cause dynamic shifts in the criminal justice system of our country. This particular bill before us, which is just a mere 11 clauses long, is intended to amend the Administration of Justice Indictable Proceedings Act 2011. This, as the long title suggests, is an Act of Parliament of 2011. But it is certainly an Act of Parliament which was long in the making, and certainly its operationalization was even longer in the making. The concept of a preliminary inquiry, as its name suggests, is an inquiry into a criminal investigation, effectively, in the magistrate's court, where two aspects of inquiry are permitted. Firstly, an accused is allowed to have an understanding of the case which is put to him and which he must answer. And secondly, the accused is permitted an opportunity to probe or test that particular case. Those are the two purposes of preliminary inquiries. Preliminary inquiries have been a feature of our law, and certainly the common law, for a very long time. As far back as nearly 464 years ago, in 1555, the Marian Statutes certainly introduced the concept of an inquisitorial preliminary inquiry. Nearly 500 years ago, an inquisitorial inquiry was had, and one can only think of the tales of history and literature to understand what a gruesome process that involved. In 1836, we get a little bit closer to what our law begins to look like. And that's where we had the Prisoners' Counsel Act. That's some 183 years ago. Of course, in 1836, we as a Crown colony were dealing with this application of law properly in Trinidad and Tobago. In 1848, we saw the Indictable Offences Act, otherwise known as the Sir John Gervais Act, and that really took us very closely to the operation of the law which we now have, which of course
is the law which was passed into the books of Trinidad and Tobago in 1917, which is the Indictable Offences Preliminary Inquiry Act. It is that act which stands on our books as Chapter 1201, as Act of Parliament number 12 of 1917. Now 102 years later, let me repeat that, 102 years later, we now seek to abolish the application of this particular law, this law of preliminary inquiries, and we seek to fashion a new system of law. This is not the first attempt to treat with this particular law. Indeed, as the amendments are reflective of work of Parliament successively, there have been some 26 attempts to amend the law as it relates to preliminary inquiries. So what's a preliminary inquiry about for persons who are not attorneys at law? A preliminary inquiry, put in very simple fashion, is the opportunity of an accused to be brought before a magistrate's court, and at that court undergo the process of examining the case put to the accused and having the attempt to probe the case to see if there is sufficient evidence to put the accused on trial. In other words, then, it is a filtration test designed to select out only cases which effectively pass muster and take them before a judge of the High Court sitting in the assizes where the matters are treated with. In Trinidad and Tobago, crime is a serious issue. And for years, successive governments have been battling with the issue of whether we have an appropriate system to dissuade people away from a life in crime. We hear the cliched expressions of if you do the crime, you should do the time. We ask people all the while to consider avoiding a life of crime, avoiding wrongdoing, so that they will not be subjected to the odium and punishment of a criminal justice system. But the efficacy of the criminal justice system is what is effectively on trial. Because if you ask the average citizen in Trinidad and Tobago whether he or she feels a sense of relief that the system is working, that there is a consequence to be met for an action determined to be a crime, where an offense is applied, the average citizen will say that they feel no form of relief. Is this new to the equation of discussion in Trinidad and Tobago? It certainly is not. When we look to the travaux préparatoires, the preparatory material that one passes through in coming to an investigation of our criminal justice system, one must appreciate that the criminal justice system is comprised of a number of elements. To have a trial, you need a judge, you need a jury, you need a witness, you need a defendant, you need a prosecutor, you need the office of the DPP's department in its operation, you need a registry to manage the paperwork and procedures, you need the prison service to keep you in remand if you're so remanded, to move you from the prisons to the courts. You need rules and operation of courts, you need record keeping, you need witness protection programs, you need police service to conduct the investigations which lead to information transferred to evidence which come before the court. Needless to say, that is a multi-dimensional equation, and as a government we have spent a significant amount of time engaged in moving the criminal justice system forward. And I propose to give the great details of that, the manner in which we have treated with each of those elemental pieces, perhaps best in my reply, because I am sure that the question of operationalization of this law is going to be foremost in the minds of honorable senators. Suffice it to say, in summary, 45 minutes not being enough to pilot the law, put it on the Hansard, and explain the outer parameters of operation, suffice it to say, we have increased the judicial capacity numerically by 77%. We have birthed a public defender system. We have introduced rules of court in the criminal proceedings rules. We have created divisions of court in the criminal division and road traffic arena, in the family and children division, in the civil division as it's coming up. And I can tell you now that we are crafting in final form a probate division so that there is a divisioning of aspects. We have introduced into the magistracy a computerized environment. We have undergone a case log backlog analysis. we have birthed in the Trinidad and Tobago Police Service a brand new prosecutorial unit which the Commissioner of Police is in complete and exclusive command of, pursuant to Section 123A of the Constitution. We have improved the accommodation and provisions of the Director of Public Prosecutions. We have improved the complement of staff. We have improved the computerized environment. We have also done a series of amendments with the laws in transferring laws from summary to either way or to indictable as we have gone. So that's the summary nutshell aspect of what senators who are by far longer in the dance than some will recognize has been properly 30 years of analysis paralysis. Let me repeat that. 30 years of report upon report upon report of we should do this, we could do this, we could think of this, are now before us. How is that to be evidenced? If you were to look to the amendments to the Preliminary Inquiries Act, Chapter 1201 alone, you will see that we have been tinkering and tweaking with the system, trying to move towards paper committals, trying to move towards an acceleration of the preliminary inquiry filtration aspect. In 2005, we had a significant amount of reform, hit the law of preliminary inquiries, and between 2005 to 2019, as we stand now, we went through a series of exercises. Very importantly, on the 11th of November 2011, we introduced this law, Act number 20 of 2011, the Preliminary Inquiries Abolition Law, if I put it that way. The Administration of Justice Preliminary Inquiries Act number 20 of 2011 was birthed. Senator Prescott sat on the independent bench then, as did I sit on the opposition bench. We engaged in robust debate. We dealt with that in the House. We dealt with that in the Senate. We dealt with that in terms of assent and operationalization. On the 16th of December 2011, this act, which we seek to amend now, was assented to by the President. And on the 31st of August 2012, as we now know, in the scandal of Section 34, there was a partial proclamation of the law. So it was at that point that we had this old law, the 1917 law, Chapter 1201. Next, we had side by side this particular Act number 20 of 2011. In that process, we then went into an exercise after the repeal of Section 34 into another law. And that was the law of 2014, which saw us deal with the administration of justice indictable proceedings legislation in a different format. The 2011 law was based upon a St. Lucia model. The 2014 law for committal proceedings was dealt with on an Antiguan model. Effectively, both laws sought to transfer out the need for a preliminary inquiry into an appropriate forum. This parent act, the 2011 Act, treats with having masters of the court manage effectively initial hearings and sufficiency hearings, and then indictable proceedings together with such summary matters or either way matters as are associated with it, they go to the High Court, or summary matters together with other matters go to the magistrate. So the route and process of this particular Act number 20 of 2011, which we seek to amend by this bill, is effectively to say, bring the matter forward, pass through either a magistrate, if that's your first point of contact, or a master, if that's your first point of contact, have a sufficiency hearing, unless you are, by the DPP's hand or by this law, not going to have it, go directly to the High Court or go directly to the summary court, which is the magistrate's court. Madam President, what time do I end in full time?
11:41.
11:41, much obliged. So let's go to the underpinnings of proportionality in the manner in which we as a government lay that track. Let's come back to the statistics. Let's come back to what our society looks like. Prior to coming into government, I had observed in my full 5 years in the Senate that we never once spoke to an ounce of statistical information in this country from Trinidad and Tobago. Speaker after speaker, government after government spoke about what happened in the UK, what happened in the US, what they found on the internet. Prior to this particular government's push for local statistics, we really were not analyzing what Trinidad and Tobago looks like. So let's go to what we look like. Why do we need to abolish preliminary inquiries? Why do we need to make sure that we are not examining the sufficiency of evidence twice? Because the Constitution prescribes due process, the rule of law, the fairness of trial, if you put it in simple terms. What is required is that an accused has a trial. That trial ought to be fair. That trial ought to be balanced. Has the removal of preliminary inquiries been tested in the courts? Yes, they have. Particularly in the Privy Council arena, where we had the Hilroy-Humphrey case, which effectively said there is no right to a preliminary inquiry, you just need to have a fair trial. So the law is settled, you don't need a preliminary inquiry, but why do we statistically need to have this in our gear? Let's turn to the statistics coming from the judiciary as are published, and let's look to the magistracy. In the magistracy, there are matters pending by offense and length of time as at July 31st, 2018. And what we've done is we've taken the opportunity to disaggregate matters pending between indictable and summary. Indictable plus summary, there are 44,183 matters outstanding. 44,183 matters outstanding. Of that, 11,210 are summary matters. So we have 32,973 pending indictable matters at the magistrate's court. They are categorized across murder, attempted murder, kidnapping, arms and ammunition, sexual offenses, narcotics, fraud, corruption, trafficking in persons, robbery, wounding, larceny, arson, escaping custody, riot, malicious damage, etc. In that pack, in disaggregating the numbers, the preliminary inquiry dance statistically demonstrates that we have, for instance, in the category of sexual offenses, 2,883 sexual offenses matters outstanding out of 32,973. And in that pack, we have 3 matters over 14 years in age. We have 1 between 13 to 14, 5 between 12 to 13, 6 between 11 to 12 years outstanding, 17 over 10 years to 11 years, 10 between 9 to 10, 8 between 8 to 9, 153 over 7 years, 205 over 6 years, 294 over 5 years. Thousands of matters in the sexual offenses arena where a witness, an accused, and the entire marching band have to appear in the magistrate's court for over 5 years from the laying of the charge. Because mind you, there being no statutory period for a crime, a rape may have occurred in respect of a minor, a child, 4 years prior to the laying of the charge, 5 years prior to the laying of the charge. And we see, for example, in the sexual offenses arena, child victims who are now adults, mothers, wives, etc., traipsing into our courts for 5, 7, 10, 12, 14 years, year on year, for a magistrate to decide whether that matter should go to the High Court to be tried. In other words, it makes a mockery of justice for the average citizen. It belies the rational jurisprudential underpinnings for the need to have sanction behind law to cause dissuasion so that people are encouraged to abide by the laws of Trinidad and Tobago. So jurisprudentially, the underpinning for a preliminary inquiry maintained in our system, as we look at the sexual offenses arena alone, the statistical information from Trinidad and Tobago demonstrates that we are engaged in the exercise of insanity. But there is a cost to this. There is a cost to this. And the taxpayers fund the cost. Statistically, we have demonstrated that the taxpayers of this country spend on average 25,000 TT dollars per month per person incarcerated in remand conditions. There are close to 3,000 persons in remand, 1,000 of them alone on matters of remand for murder, which is non-bailable. In other words, then, 1,000 times 25,000 per month, per head, times 14 years and 15 years and 16 years takes us into the realm of the billions of dollars in tax-paying expenditure. So, the amendments before the Senate today propose a slight modification of the law. We came to this Honorable Senate, we brought into effect amendments which we thought would improve the criminal arena, the criminal justice arena. We had embarked upon an exercise in 2016 and 2017 where we said, you know what, let's anchor the removal of preliminary inquiries squarely within the domain of the DPP. Let's utilize Section 90 of the Constitution, where the DPP has 3 rooted powers to commence prosecution, end prosecution, or take over prosecution in his own discretion. Let's use that to allow the DPP simply to say summary or indictable and pitch it in to the Magistrates Court or the High Court. In the course of engaging in that exercise, we were fortunate enough to put into operation 3 essential matters. 1, criminal proceedings rules. 2, new courts. 3, creatures referred to as masters of the criminal division. And in doing that, we met the 3 essential qualifications underwritten as conditions precedent for the 2011 law. Herbert Volney, then Minister of Justice, in piloting the 2011 law, said the law will not be proclaimed until we have masters, rules, and courts. We know what happened then. There was a breach of that undertaking. Section 34 happened. However, as a government, we were able to retool the criminal justice system, and therefore we were given a choice. Proceed with the amendments that we had proposed in 2016, as we had done deep consultation on, going along the DPP route, or instead operationalize a suitably amended version of the 2011 law. The 2011 law we took into a deep form of amendment. As a parliament, we specifically amended that act. That act was dealt with by the Administration of Justice Indictable Proceedings Amendment Act in February 2019. In February of this year, the Amendment Act number 3 of 2019 was assented to on the 13th of February 2019. As a matter of course, the Office of the Attorney General, prior to proclamation of law, writes out to stakeholders and asks as to the state of preparedness for proclamation. Because as a government, we're anxious to proclaim the abolition of preliminary inquiries. In the course of that consultation for proclamation, we received submissions which we thought were useful, and those submissions led us to this bill. This bill effectively asks only for a few things. In this bill, we're proposing in 11 clauses, effectively treating with clause 3 to 11 inclusive, we propose amendments which are very rational in terms of a proportionality and in terms of persuasion for amendment. What we're effectively asking to be done is we're asking for the 4 central matters that the consultation produced to be treated within this bill. 1, we want to make sure that this law, as it will come into effect, applies to all people who are arrested, not just by way of complaint leading to warrant, passing through summons, not just by way of a mechanism of a warrant or a summons to bring you to court, but instead persons who are arrested in general, because the police may very well arrest you without having had a summons or a warrant. That's 1. 2, we wanted to treat with the manner in which we manage joint trials, because obviously persons can find themselves before the court with co-accused or with multiple charges. And co-accused and multiple charges takes us into the realm of permutations and combinations, where we may have indictable mixed with summary or mixed with either way offenses, or where we may have multiple accused in that category as it is split. So that's the second aspect. The third aspect is where we want to treat with a procedure to be followed when we're transferring matters which have already commenced under the previous law. Because under the amended 2011 law, we've allowed for the prosecutor or the accused, without consent from the other, being able to bring the matter under the new law, effectively put. That's the third limb. The fourth limb is that we're treating with the fact of clarifying the circumstances where the DPP should have no sufficiency hearing. Remember, in this arena, we're treating with the fact of you come before the court, you get before a magistrate, if that's your first point of contact, or before a master, if that's your first point of contact. You have an initial hearing. At the initial hearing, there is a scheduling that happens in the course of a sufficiency hearing. The sufficiency hearing is where the master says, right, indictable up the road to the High Court or summary down to the Magistrates Court. And we skip past all of the need to filter whether there is sufficient evidence until you get to a trial. So what we are proposing is that we will clarify the circumstances where the DPP will say there will be no sufficiency hearing, proceed straight. It ties in, obviously, with the Constitution itself in Section 90 of the Constitution. So that's point number 4. There's a fifth point, and that is where we needed to clarify the language with respect to the preservation of evidence and documentary evidence. There was an inadvertent reference only to that evidence being used in sufficiency hearings. Having clarified in the amendments that we do now that there may be no sufficiency hearing in circumstances where the DPP has exercised his prerogative, either under the Constitution or under this law, we say, let's deal with where that evidence goes to for a matter that started already. So there are 5 essential core elements of this law. So let's deal with the law in the round, let's deal with the rationale for the particular amendments, and let's try to tie it in together. In that 5-prong amendment, we are proposing that we amend sections 3, 4, 6, 8, 8A, 19, 27.3, 29, and that we introduce a new section 32A. And if I were to put that into context now, section 3, which is proposed to be amended by clause 3 of the bill, section 3 proposes that we insert a modification to the definition of accused. An accused, as previously fashioned, means a person or person against whom a complaint is made or an indictment is preferred. And that definition of accused was not broad enough to factor the circumstances where a person can be charged for an indictable offense, meaning the police charged you, they didn't bring you before the court by way of summons or complaint, there was no warrant for your arrest. Let's deal with the point where you find yourself before a magistrate in circumstances where there was no summons or warrant for your arrest, no complaint. That's straightforward. That's clause 3 of the bill. Clause 3 amends section 3 of the Act. Clause 4 proposes an amendment to section 4 of the Act. Section 4 of the Act is where we had the reference to the institution of how the law is to be applied. This Act shall apply to proceedings which are instituted on or after the coming into force of this Act. And then we went on to say where proceedings were instituted prior to the coming into force of this Act, the prosecutor or the accused, both of them, may elect to have the case determined in accordance with this Act. In other words, then, that was the ability to bring the old matters under the new law. What we have sought to do is to introduce a specific route by introducing a new section 32A. Section 32A is introduced by clause 11 of the bill. Section 32A is how we transition the matters of moving from the magistrate's court to the High Court in the circumstances of Section 4 of the Act. We introduce the need for management of joint trials and 2 or more charges to be tried together. And that's where in Clause 4, in amending Section 4, we propose the insertion of a new Subclause 3. Subclause 3 effectively says, if there is a joint trial and anybody elects, make sure it's all of the joint matters going. Clause 4, Section 4.3, Subclause A treats with that joint trial. Subsection 3B treats with 2 or more charges that are to be tried together. And there we make sure that if they are going to bring the previous proceedings or new proceedings, that all of the charges themselves must be dealt with as one batch. Because it would be a tragedy to have a disaggregation of accused and also matters which would cause confusion and unnecessary costs. We then deal with Clause 5, which proposes an amendment to Section 6 of the law. Section 6 is the institution of indictable proceedings and compelling the appearance of the accused. What we propose in Clause 5, where we amend Section 6, is first of all that we ensure an amendment to Subclause 3. We said previously in the law as it stands now, prior to us asking for it to be amended, where the DPP prefers an indictment under subsection 2, the master may issue a summons or an arrest warrant to compel the appearance of the accused before him. We propose now to introduce a removal of section 27.3. Section 27.3 is removed by clause 9 of the bill. We propose to take the language from section 27.3 of the Act, transport it to section 6 by clause 5 introducing that language. And effectively we're saying in the new proposal, without limiting the generality of subsection 2, the DPP may prefer and file an indictment under subsection 2, and then we add in those circumstances for clarity. Coroner's inquest, where a co-accused is arrested at any time and you're joining him effectively to a matter that's ongoing, where the accused is charged with an offense involving serious or complex fraud, where the magistrate was unable to complete a preliminary inquiry before the coming into force of the Act, or a master is unable to complete a sufficiency hearing because of physical or mental infirmity, resignation, retirement, death, inability for any other compelling reason. And we did that to join also offenses where there's a serious sexual offense and there are threats, etc. But it is subclause D, which we had in the law in the section 27.3, which we did in February, where we treat with examples of the need for legislative clarity. As Attorney General, I took an interpretation summons before the High Court to treat with a matter which has now been concluded, which was the circumstances of Madam Justice Marcia Ayres Caesar, then Chief Magistrate, in the circumstance of her resignation, stroke, dismissal, as was alleged. In those circumstances, there was a need for clarification of the circumstances leading to retirement or resignation. We caused that amendment to be clarified in the High Court. We have the benefit of a judgment, and we have now provided for circumstances in legislation to treat with what we can call the Marcia Ayres Caesar phenomenon. It also treats with, in terms of general purport of law, and I want to repeat that, general purport of law within the meaning of the lienage line of authority, which is Privy Council authority to treat with whether law is ad hominem or not. This law is not designed to treat with any existing matter before the court. There are several existing matters before the court that fall within a general category of having gone on for 5, 10, 15, 20 years in preliminary inquiry and which involves serious complex fraud. I can also say that in the uptick of the new prosecutorial unit in the Trinidad and Tobago Police Service, I am very aware that there are serious fraud matters that are expected to be managed imminently. Let me just put it as generally as I can. In those circumstances, the last thing that this country would want to have is a 20-year sojourn into whether there's a matter to go to the High Court. Let's just get to the High Court and allow serious and complex fraud to be treated with. And I'm saying that in very general terms. We then turn to Clause 7, which proposes an amendment to Section 8A. I should add that 8 treats with Clause 6, Clause 6 amends Clause 8. In Clause 8, we're introducing a new subclause 7. This new subclause 7 treats with the circumstances where someone may be arrested otherwise than by being brought before the court by summons or by warrant. So subclause 7 treats with a person who is arrested and charged with an indictable offense, that person shall without delay, as soon as practicable after he's arrested, be brought before a master or, where not possible, a magistrate. In other words, then, preserving the constitutional rights to arrive before a court and to have your matter treated with. That would, of course, preserve the habeas corpus route, all of the other applications, etc. Clause 7 amends Section 8A, capital A, where we include the cross-references to the new 8.7 as has been introduced, and that is really a consequential amendment for the introduction of the new subclause 7. We then go to Clause 9 of the bill. Clause 9 of the bill treats with an amendment to Section 27. If we look to Section 27 and we tie it back, we are now, oh, forgive me, I have omitted Clause 8 of the bill. Clause 8 of the bill causes an amendment to Section 19 of the law. Section 19 falls under Part 3, the sufficiency hearing. And Section 19 is where you say a sufficiency hearing shall be held by a master to determine whether there's sufficient evidence. We are introducing into this subclause 19.1 the fact that essentially there will be no sufficiency hearing in circumstances where the DPP prefers an indictment under 6.2. 6.2 is where we treated with things like complex fraud, coroner's inquiry, sexual offenses where there is threat to witness. So there will be no sufficiency hearing in respect of those matters. You go directly to the trial of the matter. We then turn to Clause 9. Clause 9 is where I was referring to the amendments to Section 27. Section 27 is the discretion of the DPP to prefer an indictment. As I will remind, Clause 5 transposed effectively what was subsection 3 of Clause 27, of Section 27 of the Act, forgive me. And what we have done is to remove the reference to 27.3. We've transposed it into the earlier sections of the Act pursuant to Clause 5, which amended Section 6. So that is the tidy up aspects to Section 27 of the Act. Clause 10 amends Section 29 of the legislation. Section 29 is the admissibility of witness statements at trial. And we thought it important to cause a clarification to subclause 6. Subclause 6 said, depositions taken in proceedings instituted prior to the coming into force of this Act are permitted to be used at the sufficiency hearing. Obviously, there was an inadvertent confining of applicability to only the sufficiency hearing. That could obviously not be the intention that we had, and therefore we are now saying depositions taken and exhibits admitted in proceedings instituted prior to the coming into force of this Act shall be admissible as evidence at the trial of the accused. So we preserve all of the matters which happened by way of admissibility of evidence, loading of the record. If you're going to bring yourself under the provisions of this new law, pursuant to Section 4, pursuant to Section 6, then take everything with you and have the lawful authority to use it. And that is the essential rationale for the amendment to Section 29, subsection 6. The last section that we propose... Senator?
Forgive me, President. May I just ask the AG to offer me a more full explanation of what becomes of the sufficiency hearing that was provided for in Section 29.6 of the Act?
Sure. So,
thank you.
Section 29.6 said, effectively in the transitional environment, 29 dealt with the admissibility of witness statements at trial. So the marginal note said at trial. We all know that the marginal note is not used as any statutory interpretation, but common sense tells us that's what we intended. Section 29, in its original form, and then as amended in February of this year, we had proposed that depositions taken in proceedings instituted prior could be used at the sufficiency hearing. So we had mistakenly boxed ourselves to that evidence only happening at a sufficiency hearing. As we have seen the amendment to Section 6, there are circumstances where the DPP will say no sufficiency hearing. Complex fraud, coroner's inquiry, etc., magistrate resigned, retired, etc. In those circumstances where the DPP elects, or where an accused is in a circumstance of election, because that can happen too, and you go directly to the trial, we don't have a sufficiency hearing. So you could be faced with an argument by a charming lawyer to say, look, you can't bring all of that evidence that you had admitted already in the preliminary inquiry before, restart everything. So here it is, we instead cause surgery to 29.6 by saying everything that happened and that was admitted properly in the course of the preliminary inquiry, that can go to trial, not only sufficiency hearing.
Yeah, that is where my question was. So sufficiency hearings remain a place to which the depositions may be taken?
Yes.
Thank you very much.
Yes. So sufficiency hearings can happen pursuant to sections 11 and 12 of the Parent Act if you run the route of sufficiency hearing, because everything is brought before the master at that point. This is the circumstance where you're skipping past the master and you're going straight to the High Court judge in the assizes. Thank you, Madam President. Madam President, the last section which is proposed to be dealt with is a new section 32A caused by consideration of Clause 11 of the bill. Clause 11 invites us to insert a new 32A. 32A is effectively the transitional provision now. Subject to Section 4.3, where the prosecutor or an accused elects under 4.2 to have a case determined in accordance with this act, the magistrate shall order that the accused be brought as soon as practicable before a master to be dealt with in Part 2. In other words then, this is the trigger that invokes the magistrate to send it to the master. So we're putting a positive obligation upon the magistrate to cause the matter to go before the master. Where a magistrate makes an order under subsection 1, the magistrate shall, where it is reasonably practicable to do so, order that any summary offense with which the accused is charged and which appears to the magistrate to be related to the indictable offense be tried in the High Court. Here is where we treat with the dichotomy that England had to treat with in 2001 and then 2003 and then in subsequent amendments, because it was in these circumstances, if you follow the English jurisprudence, they dealt with indictable only matters going straight. Then they said, hold on, what about either way offenses? Then they said, hold on, what about summary matters? So they had a collective management thought over a series of years. What we have said, take the indictable thing, any either way that goes with it, take the summary that is associated with it, the judge will, pursuant to the rules, treat with summary matters as judge only, and treat with indictable matters with the benefit of a jury, or if you elect, no jury at all, as our law now successfully demonstrates that you can have trial of an indictable matter without a jury, judge-only trials. Yes, please.
Madam President, please allow me a further clarification once again, so that insofar as the magistrate has made a 32A1 order that present that the matters go before a master, how am I to read 2 that says it may go to be tried to the High Court? Does the master fall out of the process?
No. Where a magistrate makes an order where it is reasonably practicable to do so, any summary matters go along with it. So the master is always invoked in 32A1. The master is always a creature there. 32A2 says, take the baggage with you. Take the summary, take the either way, and let that go to the trial at the High Court via the master, because there's still a sufficiency hearing or the direct route if the DPP so elects. I think I have 2 minutes left or less than that. Madam President, we then, of course, in subclause 3, 4, 5, treat with the prescriptive application of how the magistrate causes the matter to move from the magistrate's court to the High Court. In a nutshell, the law is proportionate, the law is rationally connected to measures which need to be treated with. The amendments before the Honorable Senate are driven by way of consultation, emanating, causing responses to come onto the record. We are now tidying up. We are ready and able to abolish preliminary inquiries. That is a significant development for Trinidad and Tobago. Upon the passage of this law, if the Senate should be so minded, we intend to cause the consideration for the implementation of this law. This is hundreds of years too far away. It's 30 years in analysis paralysis. It meets with all of the measures that we have caused by way of operational changes, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Senator Hosein.
Thank you very much, Madam President, for the opportunity to rise in this debate, to debate what is an act to amend the Administration of Justice Indictable Proceedings Act 2011, Act 20 of 2011. And Madam President, before I begin my debate, I would just like to express condolences to Mr. Charrise Seepersad, who would have passed away this morning, prominent attorney at law in San Fernando. So I would just like to express condolences on behalf of the Senate to Mr. Charrise Seepersad and his family, his friends. And Madam President, we can all see that one day we make laws for the benefit of the people and for continuity. And we, in this Senate, should remember that that is our foremost duty. Our duty is to the citizens of Trinidad and Tobago, and to live in a more peaceful and a more prosperous society. And two of the most pressing issues in this country right now, Madam President, is that of one, the economy, and two, crime. And we must take every measure in order to deal with the scourge of crime in our society. And we have seen that the judicial system, especially the criminal justice system, has come to almost a grinding halt in terms of how matters are being dealt with in the criminal justice system. Successive administrations have come before and tried to address the situation. I must commend one, firstly, that the Attorney General would have used one of the pieces of law that was passed under UNC government in order to now be implemented to try to alleviate the burdens of the criminal justice system. But there has been a history of trying to abolish preliminary inquiries in Trinidad and Tobago. And in a nutshell, the PI basically is that any person charged with a criminal offense in this country, they start at the magistrate's court. And if you're charged with a summary offense, the matter starts and finishes in the magistrate court. If you're charged with an indictable offense, the matter starts in the magistrate court. A preliminary inquiry is conducted by the inquiring magistrate. And if a prima facie case is made out that the person would have committed the offense, then the matter would go before the High Court to be tried before a judge and a jury. And this procedure, as the Attorney General has indicated, has been existing throughout several jurisdictions for spanning almost 100 years. In 2005, then Attorney General from a PNM government would have attempted to reform the PI system in terms of the introduction of paper committals. So no longer will a witness have to go to court and have to only give viva voce evidence, meaning the witness is being sworn, placed in the witness box, and they give the evidence. The accused has an opportunity to cross-examine the witness. The paper committals would have been the filing and tendering of witness statements on behalf of the prosecution witnesses, together with the relevant exhibits. Then, ushered in a new government in 2011, the United National Congress, led by the Honorable Kamala Prasad Visesa, then Attorney General Anand Ramlogan would have piloted and passed the Administration of Justice Indictable Proceedings Act 2011. And this is the act that we are dealing with. It was a model that we adopted from the jurisdiction of St. Lucia, whereby masters are being used to conduct what we call now as sufficiency hearings. So basically, an accused person no longer has the right to cross-examine the witnesses on behalf of the prosecution. The master considers all of the prosecution's evidence and then decides whether or not a sufficient case is made out against the accused, and then commits the person to trial before a judge and a jury. And Madam President, another bill came in 2014, but I wouldn't touch that bill, and it was passed actually. But you would remember this year in this Senate, we would have debated an amendment to this very parent act. And in that bill, Madam President, we would have looked at several clauses, and the Attorney General at that stage would have indicated that these amendments were born out of the fact that he would have conducted stakeholder consultations before the operationalization of the legislation. And therefore, that would have prompted the amendment, the first amendment, I would call it, to the Act. This is the second amendment. And Madam President, one begs the question, why weren't these amendments included in that first batch of law? Why it is that we are here at this stage, coming in the same session to amend the same act? Is it that there was not proper engagement of the stakeholders? Because I looked at the Attorney General's speech in the other place, and the Attorney General would have indicated that this bill, he went back to the stakeholders. But I thought that he would have made mention of who were the stakeholders in the Senate. But Madam President, I don't know if the Law Association was consulted on this. I don't know if the Criminal Bar Association was consulted on this, Madam President. And this is a very fundamental piece of legislation, because one of the most important parts of this bill is Clause 4. And Clause 4, effectively, what it does, Madam President, Clause 4 of the bill, it allows the prosecutor, if a matter has been continuing as a preliminary inquiry before the commencement of this act, all the prosecutor has to say is that I want this matter to now go before a master of the High Court. And what is dangerous about that, Madam President, is this, is that a person would have spent a couple years before the inquiring magistrate. And then, all of a sudden, the attorney at law had an opportunity to cross-examine that witness and witnesses that the prosecution would have brought. But now, all the prosecutor has to say is that, listen, this matter I wanted to go before a master. Do you know, Madam President, that the court, the magistrate, has no power, no jurisdiction to refuse the application of the prosecution? None whatsoever. And that brings me to the point, Madam President, where I believe that we may be trampling on some serious constitutional issues. Because if the legislation and the legislature attempts to limit, Madam President, the remit of the judiciary, then definitely we have to look back at the legislation to determine whether or not we are crossing those constitutional hurdles. Because there's a case, Madam President, in Mauritius, the state against Koirati, and in that case, legislation was passed in order to deny the judiciary from granting an accused person bail. The Privy Council in that case held that when you usurp judicial function, when the legislature usurps judicial function, you are in breach of the doctrine of the separation of powers. You are in breach. And in this case, Madam President, I am seeing that a similar trend is happening here with respect to Clause 4. Because a magistrate has no power. The magistrate, all the magistrate does now is rubber stamp the decision of the prosecution, and in the bill it gives also the power to the accused. But I looked, Madam President, at Barbados, and they would have also tried to restructure their preliminary inquiries. And in their transitional provision, if you would allow me to quote, it says from the Magistrate Court Act, it says from the commencement date, committal proceedings for an existing charge shall only be conducted in accordance with the provisions of this act, where at or after the commencement date, the committal proceedings for the existing charge has not commenced. So simply that says that that the act shall not apply retroactively. But an accused person for whom committal proceedings have commenced prior to the date of commencement may, in respect of an existing charge, make an application to the examining magistrate for those committal proceedings to be continued in accordance with the provisions of the Act. So what this provision did, Madam President, is that it gave the magistrate a power now to determine whether or not the matter shall be applied under the old system or the new system. And I propose that some safeguard be given in this piece of legislation. I know the Attorney General would have said that this would have existed in the 2011 Parent Act. But, Madam President, we are a parliament. We have all taken an oath. We have said that we will protect the interests of the people. The Attorney General is the guardian of the public interest, and I think we should give the safeguard to the ordinary people of Trinidad and Tobago. Because this provision can be used by the prosecuting authorities in order, Madam President, to cause some, I don't want to accuse anyone, Madam President, but there are several cases of malicious prosecution in this case. We have seen them. And, Madam President, we don't want to run afoul of those principles when we are dealing with criminal matters especially. Because we have seen as of recently that there are a certain trend of matters that are being filed in court, Madam President, and we don't want the prosecution to use this power in order to manipulate how the prosecution goes. Because in the Constitution of this country, it requires that every person has the right to a fair trial and protection of the law. They must have protection of the law. And that is a very important issue that I wanted to deal with. Now, the Attorney General also indicated that this is not ad hominem legislation. It's not ad hominem. Madam President, I just want to reference a judgment from the Caribbean Court of Justice, the appellate jurisdiction. It's a matter involving the Attorney General of Belize as the appellant and Philip Zuniga and others as the respondents. And, Madam President, the CCJ had to determine whether or not a particular piece of legislation that was passed in Belize ran afoul of the ad hominem principle. And this is what the CCJ said at paragraph 41 of that judgment. It says that legislation prompted by the acts of a particular individual or group, accompanied by the introduction of steep mandatory penalties and providing for the rules to be made by the Attorney General, might raise a red flag, especially where the government has or may have an interest at stake. To offend the doctrine of ad hominem legislation, it must be shown that the legislature is undermining the decisional authority or the independence of the judicial branch by compromising judicial discretion. So I'll pause there. I raised the issue earlier that you remove judicial discretion. You don't give the magistrate that opportunity to perform a judicial function. Therefore, what the CCJ is saying here is applicable. First, the court's ability to address legal principles in a pending case, that is, an adjudicative process, must be negatively impacted so that it can truly be said that the legislature, in order to guarantee a particular outcome, is prescribing or directing or constraining the court in its application or interpretation of those principles. The court has to make a judgment as to whether the law in question is an exercise of legislative power or an interference with judicial power under the guise of exercising legislative power. And Madam President, I want to say that Clause 4 of this bill has guised itself as legislative power interfering with judicial power, Madam President. And this is an issue I would also like to raise. Is it that now a preliminary inquiry, a magistrate starts off by determining whether or not a prima facie case is made out. Everybody knows what is a prima facie case. It's a test for which the evidence must be such that a jury properly directed could properly convict on the evidence. R against Galbraith. Everybody knows the Galbraith test. So, Madam President, under the old system, the magistrate knows what he or she has to do, whether or not a prima facie case is made out. But when you go under the new system, there's a sufficiency hearing. And now the master has to determine whether or not there is sufficient evidence. Madam President, we don't know what is the evidential threshold for sufficient evidence. Because in the Parent Act, it was stated that sufficient evidence is a prima facie case. But that provision was deleted. So now there's a mix-up with respect to the system. So if a person decides to go under the new system, then what is the evidential threshold that one has to satisfy at that stage, having consideration to the fact that they had a legitimate expectation that the prosecution had to satisfy a burden of a prima facie case in a preliminary inquiry. So it raises certain issues there with respect to the standard of proof. Now, Madam President, there's also Clause 5 of the bill. And Clause 5 of the bill would have dealt with, the Attorney General would have gone through certain provisions at Section 5 of the bill, at Clause 5 of the bill. And the Attorney General was right that we had over 40 persons in this country had to suffer for their cases to start over, all because of improper administration of appointments, Madam President. And this legislation will now try to cure that issue. But we must remember that those persons who have been incarcerated, although the legislation is curing the issue now, no one can repay them for the time that they have lost, Madam President. No one. No one. And then you would see, Madam President, that there are certain other instances in which the DPP may just prefer and file an indictment. And one of those cases is those involving serious or complex fraud. And as I mentioned earlier, there are many cases that are now being filed before the court with respect to serious or complex fraud. And it would hurt me, Madam President, to know that we are empowering the prosecution, especially in a time where we have been seeing abuse of police powers, Madam President. And we are empowering the prosecution in these cases in order to prosecute these matters in such light. Because if you would have read or picked up any newspaper this morning, Madam President, you would have seen this. You would have seen in the Trinidad Guardian, headline, front page, lying witnesses. Lying witness. Man admits to fabricating evidence. Judge.
Pre-trial, for sub judice, please.
Senator Mark, may I be allowed to make a ruling? Thank you very much. Attorney General, the Senator is referring to newspaper articles from today, and I am listening to what he's saying. He is not infringing the standing order. Continue, Senator.
Madam President, Judge knocks DPP in triple murder case. 3 men freed after decade in jail. Newsday, 3 freed of murders after judge rules DPP was wrong. Daily Express, state witness confesses to lying. 3 freed of murder, free at last, Madam President. And a written judgment was handed down yesterday by the Honorable Madam Justice Quinlan Williams.
Madam Speaker, with the greatest of respect, we're now into the content of it, Madam President.
Senator Hosein, continue, please.
Thank you very much, Madam President. Madam President, and for the record, this is a written judgment published, and also I have checked, no notice of appeal has been filed in this matter, please. Thank you.
Need for you to be justifying anything. Please continue. I will guide you along the way.
Thank you very much, Madam President. And in this judgment, the judge would have gone through the facts of the case, and the judge would have indicated.
Hosein, Senator Hosein, while I am permitting you to make your contribution and make reference to the decision, I don't think it is appropriate for you to be going into everything in the judgment. Okay, so you need to make your judgment your presentation a little more compact.
Thank you very much for your guidance. I appreciate it. And Madam President, what the judge in that case expressed was concerns in which the exercise of the power of prosecuting authorities in this country is exercised. Because the judge found, Madam President, that certain decisions were not fairly and justly made.
Madam President, I rise on standing order 47, and I will continue to do so. I fear that my friend is on the wrong track.
Buzz, please. Attorney General, I have made a ruling and I'm allowing Senator Hosein to continue within a certain framework. I am monitoring what is being said, and I'm well aware of the standing orders. Senator Hosein, please continue.
Madam President, and these are issues that we have to raise for the public interest, because you would have to understand that persons in this country have to have fair trials. They must not be subject to political victimization. Madam President.
You have made reference to a decision. Do not try now to expand into something else that is not in the decision. Okay? So you've made reference to the decision, you've made your point. I would ask you to move on to other points. You don't have to read out the entire judgment, but you've made your references.
Intend to read from the judgment. But, Madam President, we must understand that we are empowering the prosecuting arm of this country. Now, when I was at the DPP's office, I remember that the DPP would have indicated that over 90% of the prosecutions in this country is conducted by the police, and 10% would be conducted by the Office of the Director of Public Prosecution. And, Madam President, what happened in this case calls now, Madam President, for an investigation into the circumstances of how persons are being prosecuted in this country. Because this is a very frightening situation.
Senator Hosein, no, I have to stop you here. I have to stop you here because now you're beginning to infringe the standing order. So I'm going to stop you, and you can restate what you want, but you can't present it in that manner. Okay?
Madam President, I would simply say this then, is that with respect to prosecutions in this country, a robust system must be implemented in order to protect the rights and the privileges of the accused, Madam President. Because it's very worrying, very, very worrying. And then we would have also looked at other clauses in the bill. And while the Attorney General was piloting the bill, he made reference to clause 10. And clause 10 says this, Madam President, that section 29 of the Act is amending by repealing subsection 6 and introducing this subsection. Depositions taken and exhibits admitted in proceedings instituted prior to the coming into force of this Act shall be admissible as evidence at the trial of an accused. So, let me put this into context. A person is before a court for a preliminary inquiry. The police tenders the evidence. The exhibits being tendered. When the matter reaches the trial stage, the accused person at that stage has the opportunity to challenge the admissibility of the evidence. So, for example, a confession. The confession will be tendered at the stage of the PI. But when it gets to the stage of the trial, then the judge then the accused can make an application for a voir dire to determine the admissibility of the confession. They would look at whether or not the confession was voluntarily made, if the judge's rules were properly administered, and all of those other factors. But, Madam President, what this subsection is trying to do is that you are just going to make these statements admissible at trial. When the Attorney General is winding up, I want to know whether or not the accused's right to challenge the admissibility of the evidence, whether or not that right is still preserved. Because that is an important right, because you can have confessions and admissions going into evidence that was illegally obtained, that was obtained through force and duress, Madam President, and therefore the accused person not having an opportunity to challenge the admissibility of that type of evidence. So I want some clarification with respect to that, whether or not this provision now usurps the accused's right to challenge evidence based on its admissibility. And we have to look also, because I went back to 2011 to find out what Senator Faris Al-Rawi had to say about the Parent Act in this bill, as he then was. And the Attorney General, Senator Faris Al-Rawi, as he then was, would have used the majority of his contribution to speak about the operationalization of the legislation. And we come here now, Madam President, almost, 8 years later. 8 years later. And you know what they did, Madam President? They appointed 6 masters. 6 masters to deal with over 43,000 preliminary inquiries in this country. What will happen, Madam President, is that you will now remove the bottleneck from the magistrate court and put the bottleneck in the assizes. But I want to give some statistics also, because the Attorney General also gave statistics. This is taken from the annual report of the Judiciary 2017 to 2018. In Port of Spain, the length of time a matter has been pending for less than 5 years, less than 10 years but more than 5 years is 155. Less than 10 years but less than 15 years but more than 10 years, 69. Over 15 years, you know how much matters, Madam President, in Port of Spain? 235. There are 459 matters pending in Port of Spain. In San Fernando, there are 236. In Tobago, there are 14. There are 352 matters in this country that are over 15 years and are pending before the High Court. That is unacceptable. How is this legislation going to work, Madam President? You have in this country criminal masters, magistrates, High Court judges of the assizes fighting for courtrooms in this country, Madam President. In San Fernando, you would have seen the newspaper report where one judge had to express his concern that there was not even paper to print orders for the court, Madam President. And that is the state in which this present administration has the judiciary in. You would see a big scar in San Fernando by the magistrate court because that building has been covered with a tarpaulin for months, Madam President, for months. Just yesterday, I was in one of the San Fernando magistrate court. There are persons lined up on the staircase awaiting for their matters to be heard, Madam President. The Attorney General talk about all of these courts that they are building. But where are these courts? Nobody is seeing the courts. I am an attorney. I know my colleagues here are attorneys, but where are the courts? We are not finding the courts, Madam President.
Talk about courts, boy. Courts.
The furniture store. Madam President, you are not seeing what the Attorney General is saying. Everything that they have implemented is clearly not working, Madam President. It's not working. You would see that the Director of Public Prosecution's office, we heard that they are going to be relocated months now. Months. No move, Madam President. They have not moved. The Chief Justice always complains about the recording system in the magistrate court. What has been done to assist the magistrates in that regard, Madam President? Absolutely nothing by this present PNM administration. Absolutely nothing. The Attorney General also boasts that 100,000 cases will be coming out of the magistrate court through the traffic division. Madam President, that bill was passed years now, and not a single case Not a single case was removed from the magistrate's court. Not a single one. And you would see that workers now in the in the judiciary are complaining. These are the persons who will drive this process. These are the persons who will ensure that the masters of the High Court, the magistrates, have the administrative capacity to work. And you know what they do with these persons, Madam President? These persons are now complaining, protesting almost every day because they are being asked to be removed from their permanent appointed positions to take up what? Contract employment. Removing the tenure of these persons, Madam President.
I need to just caution you to come back to the bill, okay? To be a little more focused on what the bill is about.
I'm just focusing on with respect to the court system in which this bill will have to operate within. And you would see that the 40 magisterial districts, Princestown Magistrate Court is still being heard in the Rio Claro Magistrate District, Madam President. It is totally unacceptable the manner in which this current administration has the judiciary in. Because you would see that their everyday persons are complaining about the state of the judiciary in this country. And, Madam President, I just want to also give some statistics with respect to the Magistrate Court, and I have taken it from the annual report of the judiciary. And one thing with respect to the bill that will run the system is the case management capacity of the judiciary. And what the judiciary does is implement a case management system. So if we want the matters to move forward, we must have the case management system working. If you would allow me, Madam President, this is the current status. Arima, case management system, no. Chaguanas, no. Cuva, no. Mayaro, no. Rio Claro, no. Point Fortin, no. Princestown, no. San Fernando 1, no. San Fernando 2, yes. Sangre Grande, no. Toco, no. Port of Spain, no. Tunapuna, no. Scarborough, yes. Charlottesville, no. And Madam President, that is the backbone of how the system will work. Because at the end of the day, you have a failing judicial system in this country, and there's nothing being done in order to properly manage how this bill is going to operate in the current system. Now, there are 6 masters of this of the court. Madam President, I want to ask the Attorney General whether or not these masters, some who may have come from non-criminal background, whether or not these masters are trained in order to conduct these sufficiency hearings, and whether or not a public education system will be done together with the Law Association with respect to sensitizing the legal bar with respect to this new system. Because if you would look at it, it is something very different, Madam President, to what we are accustomed to. Because the preliminary inquiries has been existing for our entire life. Some of us, Madam President, and now we are going to change it to a new system. So therefore, we must understand whether or not this will be properly rolled out in the future. Now, Madam President, there's also another area I would like to move on to. And that area is that the Attorney General did properly quote the case of Hilary Humphreys. And he stated that that case would have indicated that a person has no right to a preliminary inquiry. Because when you reach at the trial stage, it is at that stage that the person is protected and given the right to a fair trial. And the preliminary inquiry does not form part of that. It was a constitutional challenge coming out of the jurisdiction of St. Lucia. And notwithstanding that a person is not afforded the right to a fair trial, and notwithstanding a preliminary inquiry does not amount to the right to a fair trial, what we must seek to do, Madam President, is that you must have a level of protection of procedural fairness for persons in this country. And I say that on the backdrop that the Humphreys case would have dealt with prosecutions going forward. In this case, Madam President, there's a distinction to be made because you're moving from one system to the next. And therefore, we have to understand whether or not that system of moving from one system, from an old system to the new system, is in fact one in which an accused person is properly afforded the right to protection of the law and procedural fairness. Because it is an issue that we must take into consideration. Because, as I said before, the DPP in this country has a lot of powers being given to him. And there are certain circumstances in which the DPP can just prefer an indictment. Now, based on the ruling yesterday, we realize that certain constitutional challenges can be made to the exercise of the discretion of the Director of Public Prosecutions. So therefore, we might have more and more persons, when this bill comes into force, challenging whether or not their prosecution and the continued prosecution is proper. So, Madam President, we must understand whether or not that is an issue that we also have to deal with, because the floodgates of litigation in this country will open widely, Madam President. There will be a floodgate of a large amount of litigation with respect to this issue.
Senator Hosein, you have 5 more minutes.
And I'll wrap up on this point, because the Attorney General said that the legislation is not ad hominem. But if I remember clearly, the Attorney General said that there are certain cases of fraud, serious and complex fraud, that has already been identified. Madam President, that is extremely worrying to me, because ad hominem legislation means that you are passing legislation to apply to only a certain group or category of persons. And if the Attorney General is saying that there are certain cases already earmarked while piloting a piece of legislation, that raises a red flag in my mind, Madam President, whether or not this piece of legislation is targeted to a certain group or particular individuals. If that is so, Madam President, it will erode whatever confidence the people has in the prosecuting authorities and in the judiciary of this country. The government, Madam President, you will hear them on the platform. They say that there are 2 major issues in this country. I started off with that: the economy and the crime. Well, Madam President, they failed on the economy, so they're trying to address crime. And Madam President, you will see that they're doing a horrible job at it. Extremely, extremely bad. And this bill brings no comfort to the people of Trinidad and Tobago, because we have no confidence in this government that they can fix the judicial system in this country. Because when you have judges, magistrates, and court workers crying out for resources in this country, you realize that we have reached a failed state status, Madam President. The only independent arm of this country has been suffering, and under this current government and under this Attorney General, Madam President, the judiciary has been left to deteriorate. And I thank you very much.
Senator Seepersad.
Thank you, Madam President, for the opportunity to join the debate on an act to amend the administration of justice, Indictable Proceedings, Act 2011, number 20 of 2011. From the information provided by the Honourable Attorney General, in the current judicial scenario, thousands of criminal cases are stuck in the Magistrates' Court, some languishing more than 5 years in the preliminary inquiry phase with no end in sight. While the accused is denied timely justice, the victims and their families are also denied justice and closure. This proposed legislation provides hope that the travesty of justice that results from cases taking an inordinate length of time to be determined will be a criticism in the past. Madam President, the United Kingdom woke up a long time ago and abolished preliminary inquiries. Many Commonwealth countries also recognize the preliminary inquiries were pedantic and punitive because of the time lapse between charging the accused and determining if they should be committed to the High Court, we are running almost last in the race to get preliminary inquiries off the books. As the judiciary is streamlining its case flow process in the High Court, it is imperative that the focus be placed on getting matters to move efficiently in the lower courts. In the system proposed in the bill, magistrates will no longer be dealing with preliminary inquiries. Therefore, magistrates can now concentrate on summary matters. The magistrates have measures such as criminal procedure rules to ensure that these trials are heard expeditiously and fairly. That said, the role of the legislature with respect to the abolition of preliminary inquiries must be to get the proposed process reform right on paper so that it can become right in practice. The new process will call for all stakeholders to reassess their current resources and to implement measures to ensure that there is no creation of a new backlog. If the process is not properly thought through, then there'll be a real risk that matters will become stuck yet again, and there'll be no benefit from this change. As soon as possible, all stakeholders should become familiar with the proposed changes in the system. Madam President, the government must be prepared to invest heavily in all the departments and institutions involved in the new process if the proposed system is to work effectively. We live in a technological age, and we must use all the technology available to reduce the time it takes for matters to be determined by the court. All courts must be outfitted with the technology that enables digital recording and timely transcription of court proceedings. Madam President, technology must be used to make our courts current and efficient. It makes little sense to have one part of the system working if the other parts are still operating below optimum. Therefore, as this legislation is being heralded as a major initiative to remove backlogs, it is expected that all the stakeholders will be given all the necessary tools so that they can perform their respective roles in this process reform. Madam President, we must get this right. Thank you.
Senator Simonette.
Thank you, Madam President, for permitting me to join this debate on an act to amend the Administration of Justice Indictable Proceedings Act 2011. Madam President, the exercise that this government has been engaged in, led by the Honorable Attorney General, has to be seen in its context of a restatement of our criminal justice system, fundamentally aimed at addressing what has long been seen as chronic paralysis in the processing of criminal trials, whether summary or indictable. And so it is of fundamental importance for the listening public to appreciate that what we are treating with is an adjustment of the system in the public interest, away from what has been chronic and immovable systems to procedures that permit for justice to be delivered in a timely manner. The adage that justice delayed is justice denied is simply an harkening back to old words with little meaning. If in fact, those of us with the authority and the duty to change things do not intervene in a meaningful manner. And that is what my learned friend, Honorable Attorney General, is embarked upon and has embarked upon dare I say, successfully with the suite of legislative interventions aimed at improving and indeed disrupting the old system of criminal justice, as we have been deliberating with the several instruments of legislation in that regard. Madam President, the pendulum had swung hugely in favor of the offender, in that the Victorian inflexibility of inquisitorial punishment came to be ameliorated by humanitarian intervention, correctly requiring there to be a fair trial and there to be the opportunity to call evidence in defense of one's liberty. But that pendulum swung far too much in the protection, dare I say, Madam President, of the offender. In the area of the continued existence of the preliminary inquiry, that pendulum afforded the offender an opportunity to test, review, probe, and indeed frustrate prosecution efforts, and then to have a second bite at the cherry if the preliminary inquiry determined that there was a case to answer. That system in our jurisdiction, as we well know, has led to the horrific statistics that the Attorney General shared with this chamber earlier. And of course, the chronic delay in the movement of criminal trials, and indeed in the determination of whether punishment ought to be embarked upon or those accused wrongly liberated. So that the entire system, Madam President, has come into complete disrepute. And it is fair to say that regard for the law and an acknowledgement that wrongdoing will be dealt with fairly is virtually non-existent in our society. And this, in my respectful view, could well explain the wanton high levels of criminal activity in our country. So that the intervention here contemplated with the abolition of the preliminary inquiry and the speeding up of criminal process leading to what undoubtedly is still the maintenance of a fair trial and the opportunity to be heard and to defend oneself must be welcomed. It is not an answer to the task embarked upon that there has been a lack of consultation or no wide-ranging opportunity or investigation into stakeholders' comments. I think that has to be rejected, Madam President. We have not started this in a knee-jerk, nor has it been a process that has been without some considerable history of lawyers' interventions, be it criminal lawyers, be it constitutional lawyers. We have all, those of us in the profession, lived with and appreciated the very severe frailties and faults in our criminal justice system. So that when we embark upon changes that started way back with Sir Hugh Woodin's seminal article in 1962, I believe, where back then the preliminary inquiry was seen by Sir Hugh Wooding to be an anachronistic impediment to the efficient delivery of a criminal trial. It cannot be valid to complain or to assert that further or more consultation is required. We have a duty to proffer views. We have a duty to intervene and to assist, especially those of us who are officers of the court and who have obtained our training and education at public expense. And indeed, the bill that is before us, Madam President, is in fact partly produced by that recognition of the need to contribute and to intervene. The amendments that are proposed were amendments that arose from suggestions made by relevant stakeholders. And accordingly, I beg to differ with my learned friend, Senator Hosein, who considers that there need to be, or there ought to have been, more consultation.
Senator, may I clarify? Can you share with this Honorable Senate the stakeholders who were involved in this exercise?
The Honorable Attorney General shared his, this with us in his opening.
No, he never does it. I'll do it in a wrap-up. I said it. No, we don't want no wrap-up. We want it now.
Mark? Okay. Senator Simonette, continue, please.
Madam President.
Mark and Amin, please. Continue, Senator Simonette.
You see, Madam President, the task that this government is embarked upon is that of serious and deliberative intervention in the public interest. We cannot continue in this country, I dare say, Madam President, to prevaricate and raise argument for argument's sake. What is the meat of the objective? What is the nub of the issue? These are the things that we ought, Madam President, to grapple with, to deliberate upon, and indeed to dispatch by action as opposed to old talk. So that, Madam President, when we come to look at this bill, and we appreciate that what it achieves is the delivery of acceleration to the criminal justice system with proportionality maintained. And by proportionality, one is careful to indicate that nothing in these changes denies an accused the right to be heard, the right to a fair trial, or for that matter, access to all the material being marshaled against an accused in relation to the charges laid and the prosecution of the relevant matter. So that where the bill provides for the accused and/or prosecution in relation to matters that are ongoing before the bill has come into force, electing to have the matters dealt with by the master in the absence of by the master in accordance with section 32A, I believe. It cannot be that that provision is to be seen as disproportionate or in some way disadvantageous to the accused. Both accused and prosecutor are afforded the right to elect as to the procedure to be adopted. So I do differ fundamentally with Senator Hussein's interpretation on that point. Very critical to the exercise, Madam President, is the issue of not just the objectives of getting a criminal trial proceeded with, but the objective, obviously, of the appreciation that the law is not to be taken lightly, or proverbially, as it is said, to be of no value. If we can't get the criminal trials moving, Madam President, in relation to the objective of punishment, whether it be retributive, rehabilitative, or otherwise, then how can we attempt as a society to grapple with the much more fundamental issue of rehabilitation? In other words, if we are stuck at the point of incarceration of those awaiting trial, of trials taking 14 years, 9 years, and longer, how do we transform our society by engaging in a deeper reflection on the objectives of sentencing? And we haven't gotten to that in any fundamental way as yet. But of course, that is, if one is to take a holistic view of the whole approach to criminal justice, an important element of this exercise. I mention it, Madam President, because it seems to me that those on the other side are intent on standing still at the point of deliberation on whether or not the criminal trial should be tampered with in the manner in which we are advocating, with the fundamental objective from them being that we are tampering with constitutional rights. And nothing could be more fundamentally incorrect than an assertion in that regard. Ought we not to be moving forward, Madam President, past this barrier of the slow pace of criminal justice, past the barrier of an anachronistic system steeped almost in the Victorian era, to systems that permit us now to move along, to consider a wide-ranging participation of those involved on the sentencing and rehabilitative side. For example, psychiatrists, social workers, probation officers, the police, judges, and the like, in determining and coming to a view as to what ought best to be done to reverse the tendency of those, unfortunately, who have slipped into criminal activity and who, by sentencing and following a fair trial, have been required to be incarcerated for some period of time. These are the higher tenets of deliberation that I would urge my colleagues on the other side to adopt, as opposed to a facile objection to these provisions, which are demonstrably proportionate and which, in any event, do not deny the citizen the right to a fair trial. It is almost a necessity, Madam President, that we embark upon these initiatives to take our country forward and to reset the tone of civil engagement for the betterment of all. Madam President, the bill before us is therefore highly recommended. It adjusts the Parent Amendment, the Parent Act, in manner that permits not for any denial of rights, but for there to be an efficient treatment of certain aspects of the criminal justice system. The Attorney General was very careful to point out the intervention of the power to have co-accused tried and to have matters that are both summary and indictable referred to a single trial. In relation to the power of the DPP to avoid or to avoid the sufficiency hearing, of course, that can only be recommended and acknowledged in the environment in which the DPP is permitted to exercise that power in relation, of course, to serious and complex fraud, matters involving sexual abuse, children, etc., who have been threatened. So that, Madam President, there can be little argument that what is being achieved is a modernizing of the criminal procedure in relation to the administration of criminal justice. That initiative is to be welcomed, and without any denial of the constitutional rights, privileges, liberties, etc. of the citizen, I certainly support this bill in its entirety. And I thank you, Madam President.
Senator Sobers.
Thank you, Madam President, for allowing me the opportunity to contribute to today's debate on an act to amend the Administration of Justice Indictable Proceedings Act 2011. Now, oddly enough, Madam President, the last time that I was present in this August House, it was actually to contribute to a similar bill, which became Act number 3 of 2019, I believe it was. Yep. And that particular piece of legislation brought to the House several amendments to this current bill before us. So it is refreshing that we are being given a secondary bite of the cherry to treat with certain issues with respect to the bill and the amendments brought today by the Honorable Attorney General. I, just like Senator Hosein, am a robust advocate that when we sit in this parliament as legislators, we must always be mindful and cognizant of the end users of the pieces of legislation that we debate. Because at the end of the day, whatever we do within this House must redound to the benefit of the end users of the legislation, which is the public of Trinidad and Tobago. And based upon being here in January and now being here again, and treating with this very said bill, there were issues that arose in terms of our forensic audit of the bill itself that we proffered to the government then, and to be honest, the majority of those issues were not listened to. And now we are being given a second opportunity to look at the bill and to raise some of those very same issues again, and hopefully this time around they are adhered to. In particular, Madam President, much has already been said about one of the most offensive pieces of the legislation, which is in fact Section 4. And there have been amendments that have been moved by the Honorable Attorney General to treat with Section 4. But if I am to be honest, Madam President, those amendments really don't sanitize the offensive nature of Section 4 in itself. Now, Senator Hosein has in fact touched on some of the aspects of Section 4 that are offensive. And I wish now to bring a different dynamic to that Section 4. The current operation of Section 4, as it stands, reads as follows. And I would read Section 4 with having already made the changes as highlighted by the amendments moved by the Honorable Attorney General. So it says, subject to subsection 2, this act shall apply to proceedings which are instituted on or after the coming into force of this act. So section 4.2 now states, subject to subsection 3, where proceedings were instituted prior to the coming into force of this act, the prosecutor or the accused may elect to have the case determined in accordance with this act, and section 32A shall apply accordingly, and then the balance of the paragraph is struck out, and then subsection 3 is now included thereafter, subsection 2. And subsection 3 goes on to state that subsection 2 shall not apply, A, in the case of a joint trial, unless 1, the prosecutor elects under subsection 2 in respect of all the accused, or 2, all the accused elect under subsection 2, or B, where 2 or more charges are to be tried together unless the prosecutor elects under subsection 2 in respect of all the charges, or the accused elects under subsection 2 in respect of all the charges. Now, the offensive part of Section 4 is within that election process. It may seem fanciful and romantic that the bill gives an individual or the actors within a preliminary inquiry, or in this case, the actors within a preliminary inquiry, the ability to elect, to have their matter concluded or curtailed in the magistrate's court and transferred to the master's court. That both the prosecution and the accused have that ability to elect. But the difficulty with respect to that is that you can in fact have a situation, there's an absence of an agreement of both parties. So you can in fact have a situation where the accused could elect to have the matter curtailed in the prosecutor, can have the matter curtailed in the magistrate's court and then transferred to the master's court. And the danger in that situation, I have broken down into about three actually, issues. The legislation does not emphasize, or it lacks an emphasis on time and priority. So you have a situation where, I'll try to paint a picture as best as I can, as Senator Hussein also did. Persons come before the magistrate's court to have a preliminary inquiry started. This is before the legislation is enacted. Let's say this was within 2016. You have a situation where it's a capital matter, as example for murder, and the person is remanded without bail. The natural progression of the matter is such that witnesses, their statements would be sworn, filed, and then served upon the accused person. This usually takes maybe about 2 to 3 years, graciously speaking. Thereafter, the accused, either by himself or through his attorney at law, has to indicate to the prosecution which of the witnesses they intend to call. So we've sped up now from 2016 and we're in 2019. And the accused now has decided, well, out of the 30 witness statements that have been filed, I intend to call 10 witnesses. The act comes into effect, let's say tomorrow. And the prosecution is aware, the accused is aware. At that juncture, because the act doesn't say when they have to indicate, but at that juncture, neither of them wish to trigger this election process. The accused continues with the preliminary inquiry and continues to cross the witnesses as they are called. So you have the 10 witnesses, he continues to cross, his attorney at law crosses, and you reach down to 9, you pass 9 witnesses, you're on the last one. And let's say that takes the matter of itself past 2019 and we're in 2020. And right before the accused is able to complete his cross-examination of the 10th witness, the prosecution at that stage decides, listen, I want to trigger the election process.
Yep.
And have the matter transferred to the master's court. How could that be fair? That you've spent a significant amount of time as an accused person, toiling in the magistrate's court, treating with your matter in a particular way, have arrived or have formed some degree of a legitimate expectation that a matter that has been started should be completed, whether it be by guilt or by discharge. And all of that is now curtailed by a prosecutor who decides at this juncture, because the law doesn't say when the election process has to be triggered or takes place, he decides, right, matter needs to go to the master's court now. I don't want to deal with it anymore. No emphasis on time could allow for something like that to happen. And it is something that we cannot allow to pass in this House, because it could in fact be abused. Apart from the law not having an emphasis on time, I also mentioned the fact that there's no mention or contemplation of priority. So we use the same example again. Matter started in 2016, progresses through, we're in 2019 now, start a cross-examination, whatever. 2020 comes around, and the prosecutor decides at that juncture, listen, time to curtail, send it to the master's court. It isn't a situation where the matter is now going to be transferred to the master's court, and you are now going to be ahead of the line, you know. You're going to be in the back of the queue that has already started.
Pick and choose matters.
All the matters that have been transferred from the magistrate's court, the new matters that have been started and now are going to the master's court, there's going to be a queue there. All the other accused who may have elected from 2019, if the legislation comes into effect, and elects to have their matter transferred to the master's court, they are going to be in that queue. And you, who had a legitimate expectation that your matter was going to be concluded in the magistrate's court through a preliminary inquiry, you're going to be in that queue as well. So having spent almost 4 years in custody on remand, and as the Attorney General said, $25,000 per month per person on remand by a taxpayer for 4 years, you are now going to be in the back of this queue in the master's court. What is your position then? You have to sit and wait for your matter to come up before a master for it to be dealt with, because there's no emphasis of priority, no inclusion of priority within the legislation to treat with matters that have been transferred to the master's court. And this is another travesty that could in fact take place. Looking at the lack of emphasis of time and the lack of emphasis on priority within that section 4, and looking at the amendments themselves, I found it very strange that with respect to an election situation in section 4, wherein it is separated with respect to either and not an agreed position,
that if we are to consider continuity throughout the amendments, all the other instances where an election process should take place, it should be separated like that. Which brought me to consider Clause 11 under Section 32A, Subclause 5, Subsection 5B. You would have a situation where, in terms of the natural transitional process of the matters coming before the master, when you look at 32A, Subsection 5, it states, where an order is made under subsection 1 or 2, the accused shall appear before a master on A, the next available session day, as determined by the registrar, or B, such other session day as may, subject to the approval of the registrar, be agreed between the accused and the prosecutor. So you're allowing an agreed position to happen between an accused, and I had a difficulty with this in January. I still have a difficulty with it now, because I find it highly untenable to have a situation where a matter is to be fixed for mention at that stage before a master, and you're going to give an opportunity for both the accused and the prosecutor to agree on this fixing date. But you're allowing, in this part of the amendment, an opportunity for an agreed position to take place between the accused and the prosecution, but with respect to something as much more serious as his legitimate expectation with respect to his trial in the magistrate's court via preliminary inquiry, there is no agreed position. It is absent. Even when we look at Clause 5, Section 6, which treats with the, for lack of a better terminology, the Marcia Caesar situation, wherein you would have placed safeguards to treat with a situation like that, where matters would have started before a magistrate or a master in this case, as the amendment allows. And for these particular reasons, because of physical or mental infirmity, resignation, retirement, death, or inability for any other compelling reason, the matter is curtailed. You now have a provision where the evidence filed before, in my opinion, it should be the court and not the master, discloses in the opinion of the DPP sufficient evidence to put the accused on trial. This particular amendment would treat with situations where matters would have been curtailed or cut short. So you have a plug in the hole that was caused by the Marcia Caesar situation now being put into legislation. But yet now, within the ambit of Section 4, there could in fact be situations where matters are again going to be curtailed. Because wherein you have a situation, as I just mentioned, where you had your matter started in 2016, it continues throughout 2019, and then it goes into 2020, and you're almost finished with your matter at the magistrate's court, and the prosecution decides to elect to have the matter transferred to the master's court. Guess what? Your matter has just been curtailed. Your matter has to now restart again. The same plug that you've put later down in the legislation to stop the same travesties of justice with respect to rioting for that situation in the magistrate's court a couple years ago. You leave it widely open now to reoccur again in this ambit of Section 4. And that is not the actions of a responsible administration. Another point that I looked at with respect to Section 4 is the issue of retrospectivity. Because this particular Section 4 deals, it does have a retrospective nature about it, because it treats with matters that have occurred or have started before the coming into force of this legislation and are going to be affected when the legislation occurs. And Madam President, if you would allow me to read from the case of Wilston versus County Trust Limited, number 2, 2004, 1 AC 816. And it deals with retrospective application, the dangers of retrospectivity in legislation. Retrospective application of procedural rules. The impermissibility of retrospectively applying substantive laws is well understood, particularly in the criminal sphere. The retrospective application of procedural laws is not in itself objectionable, but it is recognized that the retrospective application of procedural laws is capable of causing unfairness. I can think of no other example of a serious unfair situation that can be caused if these matters are called to be cut short or curtailed
by a prosecutor in a situation where you've already spent a significant period of time treating with a matter in the magistrate's court via the preliminary inquiry. Also, in the case of Lofis Sheriffen Dis Phosphates versus Yamashita Shinon Steamship Company Limited, 1994 1AC 486, it stated in the present context, it also stated, with respect to the retrospective application of new law to an ongoing matter, it creates an obvious risk of unfairness for the reasons outlined. So on this analysis, the prosecution's unilateral power to cut short a preliminary inquiry and opt out into a new piece of legislation should also be considered impermissible. Sorry.
Honorable Senators, we will now suspend the sitting and return at 2 p.m. Senator Sobers, you have utilized 17 minutes of your speaking time, so we are suspended until 2 p.m.